Hello, everyone, and welcome to today's webinar, 2025 Legislative Update, Key HR and Compliance Changes You Need to Know. I'm Lauren Corrigan, and I'll be your host for today's session, brought to you by MP Wired for HR. We are thrilled to have you join us because, let's face it, staying compliant in 2025 isn't easy. At MP, we're more than just a payroll and compliance vendor. We're your proactive HR partner. Our team of certified HR pros work with organizations like yours every day to navigate complex compliance issues, manage risk, and align people's strategies with your business goals. And yes, that means we read the fine print so you don't have to. As we officially move past the halfway mark of the year, somehow it's July already, where the legislative landscape is shifting fast. Our HR and compliance experts are going to break down exactly what's changing, what matters most, and what smart organizations are doing right now to adapt. Before we get started, we're going to do a quick poll and get a pulse on what you're most interested in learning about today. Give you guys a little bit here to enter in your poll, and then we'll take a look, and Paul, let you analyze the results a little bit, and then we'll get to some housekeeping. And I can
Sounds good.
All right, guys, we still have some answers pulling in. I'll give you a few more seconds. All right. Get your answers in 3, 2, 1. All right, Paul, this is what our audience is interested in
All
today.
right. This is perfect. We'll be covering all of these things, but I'll make sure to tailor my talking points accordingly.
Awesome. All right, a few quick housekeeping notes. Drop your questions in the Q&A. We'll cover as many as we can at the end. Yes, this webinar is being recorded. We'll send you the replay afterwards. Also, yes, this SHRM and HRCI credit details are coming at the end, so hang tight. Leading today's session is Paul Corellis, VP of HR Services. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul leads a team of SHRM certified HR professionals here at MP. Together, they assist clients with compliance, training, and HR guidance and support a full employee lifecycle. And with that, Paul, hand it over to you.
Awesome. Thank you so much, Lauren. Really nice intro there. Appreciate everyone who participated in the poll. Really love hearing what everyone's looking to talk about. Sometimes this is an annual presentation that we do. It's always one of our more popular sessions. This year, no exception. And to be honest, sometimes we're kind of scrambling, what information are we going to pull here? How are we going to fill the time allotted? That certainly was not the case this time around. It was more about what's going to hit the chopping block. What can we cut out? Just because there is so much going on and so much that's impacting employers across the country and across the world. And so many things happening from a HR and regulatory and employment law standpoint. So I won't waste too much time, and I'll dig right in to make sure, A, that we have enough time to cover the information I want to talk about. And I also tried to save some time for Q&A as we like to do. So as Lauren said, do feel free to put questions in the Q&A portion of the Zoom, and we'll get to as many of those as we can as time allows. So what I hope to cover this afternoon, first, we will be talking about the one big beautiful bill that was the #1 on the poll we just did in terms of what people are hoping to learn about today. So we will cover that. We'll talk about what's going on at the federal government, both within the White House as well as at the various federal agencies. We'll talk about some really key Supreme Court and other court rulings that have happened since 2025 started and how those are going to impact your best practices as an employer. We'll also talk at the state level and go over some of the state laws that took effect this past July 1st. We'll also talk about some trends, what some states are talking about in their respective legislatures. And then we'll kind of close with an HR employer checklist. So what are some things you can do now to help prepare you for the second half of 2025 and as you head into 2026? So Lauren, if you wouldn't mind bringing up our second poll, I just wanted to kind of gauge people's familiarity and comfortability with the big beautiful bill. So if you could just take a second and just share how you feel you and your employees and whether or not you have a good understanding of how this bill is going to impact your workforce.
They'll have some responses rolling in. I'll give you a few more seconds.
Cool.
All right, everybody. 3, 2, 1.
All right. All right. So yeah, definitely a lot of uncertainty out there. No surprise. There's a lot to it. It's hundreds and hundreds of pages of legislation. Um, and it's something that I'm still piecing through a little bit myself, looking for any other nooks and crannies that we may have missed. But that being said, we're going to do an overview to hopefully make you feel a little bit more comfortable with it now. We've got a lot of content on this coming as well. Between the 5 minutes with an HR pro, we'll be sending out some newsletters. We're hoping to do a dedicated session just on this bill next month. And what we would do there is today we're going to kind of cover what's in the bill that's HR and employment relevant. We'll also in the extended session, cover some things that weren't in the bill that may have been in previous versions, or might be some kind of myths or confusion about what was in the bill. And then lastly, we'll talk about strategy in terms of how to leverage those things. So in terms of the current HR headlines as we see it, big, beautiful bill number one, as supported by the polls we just did. Second, pay transparency, which was number 2 in the poll, interestingly. So it's just really starting to grow in a number of states. I know we have a lot of people here on the call today in states that are being impacted by this now or in the very near future. New Jersey, Vermont, Massachusetts are the big 3 right now. And then the courts and agencies. So every day when you open the newspaper, turn on the TV, turn on the radio, hop online, whatever it is, you're seeing a new court ruling that's either blocking something that an agency announced, blocking something that President Trump announced, overturning something that was blocked, what have you. So it's just a constant volley match going back and forth, and it's tough to keep up with. So definitely stay tuned to us, and we'll keep you apprised of the latest. And then artificial intelligence. So that's not going away. We talked about that a lot last year, and it's only grown in significance and adoption. And one thing that did hit the cutting room floor when it comes to the final version of the One Big Beautiful Bill was something that was talked about that would have restricted states from passing their own state level AI regulations and laws. So that part was not included in the final version of the bill, which means expect to see more and more states adopt some sort of artificial intelligence regulations, rules, boundaries, whatever they may be. But you're likely to see that coming in the next year or so. All right, so in terms of the bill, far and wide, the number one question or 2 top questions we're getting about this have to do with the quote unquote no tax on tips, no tax on overtime, getting questions from employers, getting questions from employees. So I wanted to break those 2 provisions down a little bit further for everybody. So I think the first thing and the most important thing to get across, especially to your employees who are expecting to see a difference on their paychecks if they do receive tips or do receive overtime, is that the impact of this is not going to be immediate. Yes, it is in effect right now, but it is not like what we saw, at the state level. I think it was Alabama who exempted overtime from state taxation. This is not an immediate tax relief. It is a top line tax deduction that these employees will claim when they file their personal taxes at the end of the year or by April 15th of next year. So this isn't going to affect what occurs on an employee's paycheck. So with the tips piece of this, it's going to be a tax deduction. It's capped at $25,000 per year. There are some income limits. So if a single filer earns more than $150,000 in a year, or as a joint filer, they earn more than $300,000 per year, the amount of the deduction starts to reduce when income exceeds those amounts. It's important that they really carefully defined what tips are. So these have to be at the discretion, and the amount has to be at the discretion of the customer who's providing it. So in an instance where there's a mandatory service charge that automatically is added to a party's bill, think about, functions and things like that, where they automatically add a 20% service charge. Under this law, that does not count as the tips and would otherwise be subject, just like any other wages, as taxable wages. They also, you'll see language if you look at the bill that it talks about cash tips. So there's been a little bit of confusion with that. At first, some people thought, well, that only means if someone leaves actual dollar bills on the table, those are going to be tax-free. But if someone tips via credit card, those wouldn't be. That's not the case. What they mean by cash is just monetary gratuities. So whether it's in the form of cash or credit card tips, those both count towards this and would be eligible for the tax deduction. So don't get confused by the term cash there. What it just means is that it can't be a gift. If someone is tipping someone with tickets or a gift basket or something like that, then the value of those is still subject to taxation, but cash tips are not. You'll also see the term, and I put it in quotes here, customarily and regularly. So this has to do with what occupations qualify for this deduction. So it has to be an occupation that customarily and regularly received tips prior to the end of last year. So it can't be something where all of a sudden the company says, hey, this job has never typically received tips, but we want to modify the comp structure, so we're going to make this now a tips position. The Department of Treasury has been tasked within the next 90 days to come out with a list of what the qualifying occupations are. So expect to see that within the next few months. They have already come forward within the bill and announced some occupations that do not qualify for this. Things like financial services, performing arts, sciences, things like that. They're really going to narrow it down to your typical and customary tipped occupations. Another caveat here, and an important qualifier, if you do have employees who have a TIN rather than a social security number, and that's what's used on payroll, to qualify for this tax deduction, the employee does, and their spouse, if they're filing jointly, need to have their social security number on file and as part of their tax filing. As an employer, the thing that you do need to make sure of, and if you're with MP, you'll be all set. But if you're not, definitely check with your payroll provider. This itemized kind of tip figure is going to need to be included on W-2s going forward, because that will be important. That is what the employees will use to claim this deduction at the end of the year. All right, so let me just check here. Next, let's talk about overtime. So there are some similarities and some differences with the no tax on overtime provision. So it's similarly, this is not going to be something where overtime is not taxed at the time that it's paid out. This is also going to be a tax deduction at the end of the year for the employee. The amount of the tax deduction depends on whether the person is a single or joint filer. If it's a single filer, the deduction is capped at $12,500. If it's a joint filer, it's capped at $25,000. So this is subject to the same income limits as the tip portion, 150 or 300,000 for joint filers. It doesn't automatically go away at those income thresholds, it just gets reduced. One important thing here that a lot of people aren't talking about are some of the limits to how this is calculated. So first, only overtime required by the Fair Labor Standards Act is eligible for the tax deduction. So that means if you're in a state like California, which requires overtime for more than 8 hours worked in a day, that time after 8 hours isn't necessarily eligible for this tax deduction. Also, if you have a company policy that says, hey, we pay overtime when people work more than 30 hours, work more than 35 hours, whatever it may be, that is not eligible either. It's strictly for when more than 40 hours are worked within a work week. So as required by the Federal Fair Labor Standards Act. Another thing that I really haven't heard anyone talk about that's very important is that this tax deduction only applies to the overtime premium. So that can be a little bit confusing. So I put an example here on the slide. So if you have an employee who earns $20 an hour, their time and a half overtime rate would be $30 an hour. The tax deduction is not on that full $30 an hour that they're working when they're working more than 40 hours in the work week. It's only on the overtime premium. So in our example here, the eligible tax deduction for this overtime would be $10 an hour, the difference between their regular rate and their overtime rate. So I think that's going to be important too. And that could be a big surprise for employees who are expected to be able to write off all of their overtime when it's really going to be limited to both the deduction cap as well as this calculation that we just spoke about. Similar to the tips provision, this also requires the Social Security number for everyone on the return to be included. This is also going to be important to be shown on the W-2, so that's going to be a change. Right now, W-2s do not reflect overtime apart from regular wages, so that's going to be a new wrinkle and a new requirement for payroll providers. And then it's also important that employers can't count any tips towards the overtime or vice versa. They can't double dip on these two programs. All right, so aside from that, there are some other HR and employment relevant items within the Big Beautiful Bill. First, there's some changes to ACA coming. So there's going to be a reduced window for the open enrollment on the exchange. They're going to be cutting that by 1 month. There are also going to be more stringent requirements to prove eligibility and income. And there are also going to be some changes to the subsidies that had been in place before for folks who aren't offered affordable coverage from their employer. So it will restrict the marketplace exchanges somewhat. The previous administration had passed some staffing mandates for nursing facilities, nursing homes, and things like that. This bill puts a moratorium on that for 10 years. So those staffing mandates are put on hold until 2034. So if you are in the nursing business and we're sweating those staffing mandates, those are on hold for a decade, unless something else comes along and changes that, of course. There has been an expansion of the paid family medical leave tax credit for businesses. So something you want to talk to your accountant about. But if you do offer paid family medical leave or have paid towards an insurance for that, or what was added as part of this bill, if you're subject to any costs for a state-run program, you'll also be able to get a business tax credit for that under this bill. There's also an expansion of childcare credits. So for employers who have on-site childcare provided, that's expanding the credit available to those businesses. Also, for businesses who offer an FSA and have that dependent care portion, you're probably familiar with the $5,000 annual childcare FSA limit. That next year is going to be bumped up to $7,500. So a pretty substantial increase of 50% on the childcare FSA. They're also going to be reverting back to some old 1099 minimums. So this will start next year, not for this current tax year. But I know a lot of us have been used to that $600 threshold before as a de minimis amount before a 1099 has to be issued to an independent contractor. That's going to bump back up to $2,000 starting next year. And for folks receiving a 1099K, so that's often your gig workers, people doing Uber and DoorDash and things like that. The limit for that starting next year is going to be $20,000 and 200 transactions. So you'll see fewer 1099s being issued to those individuals starting next year. Also, some changes to health savings accounts, which can be a great tool in certain situations. What this bill will provide is automatic HSA eligibility for any marketplace bronze level or catastrophic plans. So if you're familiar with HSAs at all, you'll know that generally only people who are part of a high deductible health plan can participate in HSAs. So this will open this up somewhat for folks. So anyone who's on a bronze level plan or a catastrophic plan through the exchange will be eligible to participate in a health savings account. And this also, within this bill, allowed for telehealth to be automatically allowable through HSAs as an allowable expense. And then finally, some employers had been taking advantage of a temporary rule that allowed employers to repay or reimburse employees for student loan repayment and use the same kind of tuition reimbursement limits to keep that being tax-free. So that was set to expire, I believe, at the end of this year. Within the big, beautiful bill, that was made as a permanent program. So if you are repaying student loans and taking advantage of the tax advantage of that, that is now a permanent program. So you don't have to worry about that expiring. All right. So if you've followed the news at all, I'm sure you've seen just the flurry of executive orders that have been coming from the White House since January, many of which do affect employment, HR, things of that nature. The first of which that was issued had to do with DEI. So what that did was eliminate DEI programs within the federal government and federal agencies. Also put restrictions on federal contractors in terms of DEI. There wasn't anything in there that necessarily stopped private employers from continuing the DEI programs, but I will say that several of the agencies, EEOC and the like, have been instructed to inspect those and make sure that they're not discriminatory in their nature. So if you do have a DEI program, even if you aren't a federal contractor, it's something you're going to want to look at with an HR professional or perhaps legal counsel, just to make sure you don't have unnecessary exposure with the way your DEI program is drafted and being utilized. There was also an executive order regarding artificial intelligence. So if you were on one of our previous legislative updates, you'll remember that the Biden administration put together a pretty sweeping artificial intelligence executive order that required guardrails and reports and testing within the federal government. What President Trump's artificial intelligence executive order did was essentially wipe all of that away, kind of rescind the Biden era executive order on AI. Also, a executive order on disparate impact liability. So really instructing federal agencies to not factor in disparate impact when it comes to liability. So those are sometimes programs that, whether intentional or not, disparately impact certain groups of people based on the practice of the program. So trying to move away from that within that executive order. There was also an executive order with directives for the Department of Transportation that for folks in the trucking industry, that a requirement that truck drivers all have English proficiency. So if you do employ truck drivers, that's something you're going to want to speak with an HR professional about. Make sure you're in compliance with that because that is seemingly moving forward. And then finally, for employers who utilize visa workers, either folks on, students who are using related visas that allow them to work, or H-1Bs and pure employment visas. As I'm sure you've heard, they've started to undertake much stricter vetting and processing qualifications for visas. So if you do utilize visa workers, at the very least, expect delays. At the worst, expect there to be, denials of certain visa workers and things like that. So just be mindful of that and plan accordingly. Another item, speaking of immigration, that hasn't been getting as much media attention and publicity is the termination of temporary protected status, or TPS status, for workers from certain countries. So you may or may not be familiar with this, depending on the demographics of your workforce, but over the last couple of decades, there have been several countries who have received what's called TPS, or temporary protected status, which, because of the conditions in their country being deemed unsafe by the Department of Homeland Security or other relevant departments, that They're kind of allowing these employees to remain here as refugees. They are issued EADs, or employment authorization documents, that for a finite amount of time authorize them to be employed in this country. Those EADs are valid for purposes of I-9 and work authorization and things like that. So what's been going on this calendar year is that the Department of Homeland Security and the Trump administration has been revoking TPS status for countries that they feel no longer kind of meet that criteria. What they say is that some of these TPS agreements are being abused, so they're ending them, which means that unless the employee has gone forward and gotten a permanent resident status or a citizenship or some other type of residency or work authorization, that as of the specific date that the termination is effective, they're no longer authorized to be employed. So some of the countries that have recently lost their TPS status include Honduras, Nicaragua, Venezuela, Afghanistan, Cameroon, and Haiti. So if you do have employees that are here on EADs from these countries, you're going to want to double check. Sometimes it's only certain employees from these countries, that sometimes there are multiple instances of TPS, and depending on when they came here, their EAD may or may not still be valid. So it's definitely something you want to take a look at, speak with an HR expert on it. And there still are employees from other countries who do have valid TPS. I know Ukraine is one, Sudan is another. There are still, not all EADs are necessarily null and void, but a growing number of them are. So again, a great time to be reviewing your I-9s and your authorization documents to make sure everyone that you have on staff is authorized to be working. All right, so let's take a deep dive into some of the federal agencies. So continuing the theme of immigration, it's all over the news, but Immigration and Customs Enforcement, or ICE, has really been doing a ton of workplace inspections, a big surge in that. So that's when they're physically entering workplaces, inspecting documents, speaking with workers, detaining folks as appropriate. We're just seeing a lot of that. Also, a lot of I-9 audits. So for the first time, we're seeing those at the state level as well. So we're seeing some state agencies auditing I-9s, which I hadn't seen in my career in the last 20 years or so. So that's a new wrinkle. I-9 compliance is more important than ever, just because whether it's a on-site inspection or whether it's a paperwork inspection, they are auditing more and more I-9s every day. So if you use the paper forms, you're going to want to review those. If you do use electronic I-9s, there are specific requirements for those in terms of how the information is stored, how the information is entered, how it presents itself at the time of audit. So if you are using electronic I-9s, just make sure that you're checking all the boxes for compliance with that as well. And then what we've been doing for a lot of our HR services clients who just want to feel secure, want to feel safe, or have managers that are nervous about this, is it's really in your best interest, especially if you're in a high risk industry, to have a playbook for how to handle workplace inspections by ICE and properly train your managers, again, at the very least, so that they feel comfortable. So it's not something weighing on them, so that they can focus on the job that you have them hired for and not be constantly worried that ICE is going to come in and they're not going to know what to do. So it's really good to, at the very least, have a checklist or some documents about what your protocols are going to be, or even better, if you can have a playbook. All right, so over at the Department of Labor, they've been busy. Just this past July 1st, in accordance with an executive order by President Trump asking agencies to deregulate, on July 1st, the Department of Labor introduced what they call their deregulatory agenda. So there are a number of areas where they're looking to deregulate the agency, some of which involve healthcare and home health and some FLSA provisions specific to home health workers. Also some rules around federal contractors and some regulations having to do with the General Duties Clause and OSHA. So it's important to note that what happened on July 1st was just kind of the preview of what they plan to do. This didn't change things as of that date. It's kind of one of those things where we're just going to have to be patient and see it through. So the next step in the process for that will be the department entering in the specifics of these deregulatory actions in the Federal Register. There'll then be a comment period and a public comment period for folks to weigh in on those. And it'll go very similar to the standard rulemaking process before there are actually any changes. So again, just really important to stay tuned. Keep working with us, stay on our mailing list, keep attending our events, and we'll keep you aware of the latest with that. This Department of Labor is also returning and expanding the opinion letter program. So that's something where employers, employees now with the expansion, members of the general public, folks like us at MP can submit a question or a scenario to the Department of Labor and then get a formal opinion that's published on the DOL website, among other places. So the previous administration had really shied away from doing opinion letters. And the current one has brought back several of the opinion letters that previously weren't being utilized, and again is also expanding the program to include some other agencies such as OSHA and things like that. Another item from the Biden administration that's being reversed, although we haven't seen the formal action of formally rescinding the rule, is that they announced, I believe about a month ago, that they are no longer going to be abiding by the 2024 independent contractor standard. So that required a heightened test for determining whether a worker was an employee of a business or an independent contractor that wasn't subject to Fair Labor Standards Act or other minimum wage, other workplace protections. So basically what they said so far is they're reverting back to the pre-2024 standard, which is a bit of a lower bar and allows more workers, at least from federal view, to be considered independent contractors. It's important to note if you are in a state that has their own test for W-2 versus independent contractor, that you're following whichever is more strict. So if you are in a state with its own test, make sure you're following that. And this DOL ruling does not affect you all that much. One really interesting memorandum from the Department of Labor that came out about a month ago was from the Wage and Hour Division. So historically, when the Wage and Hour Division proceeded with a case against an employer where they found that they violated the wage and hour rules and the Fair Labor Standards Act, that business would be responsible for the actual damages as well as liquidated damages, which were generally a doubling of the original amount. So if an employer mispaid an employee and owed them $500 in overtime pay, there would also be $500 in liquidated damages. What this Department of Labor said is they're doing away with that outside of litigation cases, which they kind of lose control over. When things are handled within the Wage and Hour Division of the Department of Labor, as of the end of last month, I believe it was, they were not going to seek liquidated damages against employers. If there's a case that was already in motion, it does not go retroactively. This is just going forward. I believe it was June 26th on. And then finally, OSHA is a part of the Department of Labor. And they did announce recently as part of their agenda items that they are seeking to both reduce the OSHA budget as well as staffing, cutting several staff members from the OSHA department. And the way they're explaining this is that they're going to focus more on compliance and supporting employers and get away from so much inspection as they were doing before, to more focus on compliance rather than coming down on employers for OSHA violations. So we'll see where that lands. It's obviously still very important to make sure you're following the OSHA laws at any given time, but you will see some changes and some shakeup there within that department. All right, so over at the EEOC, we've got some interesting things going on over there. The first of which is that currently because of some folks that President Trump removed from the Equal Employment Opportunity Commission. Those were challenged. At one point, a court allowed the person who sued back on the EEOC, then another court reaffirmed Trump's decision and kicked them back off. So as of right now, there is not a quorum at the Equal Employment Opportunity Commission. So there are some restrictions on what they're able to do in terms of formal rulemaking. They don't have enough members on the commission right now, but they are, based on how they're set up and how their rules work, they are allowed to proceed with cases. Something that they've kind of gone back and forth on were cases involving gender identity discrimination. So earlier this year, they had kind of announced and directed the commission to deprioritize cases that involve gender identity, to move them down to what they call, I believe, the C priority list. And then just recently, they did decide to kind of reverse course on that. And based on the merits, they did redirect the agency to start examining some of those and pursue them if there is indeed discrimination going on there. Hopefully, if you're over 100 employees and or a federal contractor, you recently completed your EEO-1 filing. The window for that, excuse me, did close a few weeks ago. One change that they did make with this year's filing of the EEO-1 is that there had previously been the opportunity for employers to mark employees as non-binary. So if you're not familiar with the EEO-1, what that is a report filed with the Equal Employment Opportunity Commission that reports on an employer's workforce based on job responsibilities, gender, and ethnic background. So again, the last couple of years, there had been the option for non-binary. That went away. That was not an option on this year's filing. EEOC also earlier this year announced one of their enforcement focuses was going to be on illegal preferences against American workers. So what that means when you boil it down is they just wanted to ensure that employers are not abusing visa programs, immigration programs for employers and things like that, that they're first combing the American citizen workforce to find employees before opting for visas or non-American workers. One thing to be especially mindful of and be on the lookout for, once the EEOC does have quorum, once they do kind of restock the commission with board members, is the Pregnant Workers Fairness Act. And I just say that because the current commissioner has said in previous meetings and speaking engagements that is something they want to look at, potentially rescind, potentially pick apart a little bit, because there are some aspects of it, particularly protections for workers seeking or obtaining abortions, that they may want to look to do away with some or all aspects of the Pregnant Workers Fairness Act, which was just passed a year or two ago. So as that changes, again, we'll be sure to keep you updated, but it may be an impact to the workforce. All right. And then finally, the National Labor Relations Board. So similar to EEOC, they're short of members right now. That's probably going to change fairly soon. President Trump has nominated some folks to serve on the National Labor Relations Board. They are a little bit more restricted when they do not have quorum. So there's a little bit less that they can do right now. But that being said, the acting general counsel, which is a very powerful position within the National Labor Relations Board, they're basically the general counsel is who oversees which cases the NLRB is going to hear once they're able to, so they can kind of pick and choose what they want to rule on and what kind of precedent they want to set. They can also issue memoranda that give some direction to the regional offices, and they can also rescind previous memoranda. So they have gone ahead and done that to some extent. The first of which was rescinding a previous memoranda that stated that it was in the NLRB's view that non-competes were generally not permissible and not legal. That has been rescinded, so that is no longer the stance of the current National Labor Relations Board. There's also been some rescinding on restrictions on captive audience meetings, which is when an employer has a mandatory meeting and uses it to speak to the employees, their thoughts about not forming a union or not collective bargaining. They've also rescinded orders having to do with severance agreements and specifically pieces that have to do with non-disparagement clauses. So they're more open to non-disparagement clauses now within severance agreements. One interesting thing that we're seeing is that because the National Labor Relations Board cannot decide cases because they don't have enough members, and there are certainly things going on having to do with collective bargaining and unions, we've seen a couple states, I believe California and New York being the first, that are passing laws to allow them to kind of hear these cases at the state level. And obviously the federal government isn't crazy about that, so we'll see where that ultimately lands, but we are seeing some states trying to get involved with a lack of quorum at the NLRB currently. And then finally, the General Counsel has said their emphasis this term is going to really be focused on settlements and empowering the regional NLRB offices to go into settlements rather than having things rise to cases at the federal NLRB level. So we'll see what that looks like on a case-by-case basis, what kind of precedent that sets, and what the best practices are for employers. So, one thing I always say is while a lot of times NLRB items, employers assume that just has to do with unionized workforces. That is not the case. They do oversee the National Labor Relations Act, which gives folks the right to organize and collectively bargain. But the NLRB also rules on several cases where employees' rights are being chilled or contained that would allow them to do that, even if it isn't in that same organizing context. So NLRB is an important agency to keep your eyes on, whether or not you're working within a unionized work environment. All right, so one key thing as a takeaway here, and Lauren, I might have you bring up our next poll. A common misconception that employers make is that when we see things like this, the federal government deregulating, we take our eyes off the ball a little bit and say, hey, I don't have to worry about this at the Department of Labor anymore. I don't have to worry about that at the EEOC. That simply isn't the case. Well, certainly at the EEOC level, we're still seeing a ton of action, a ton of employers getting in trouble, getting fined, getting penalized for discriminatory conduct. But also what we see when there's federal deregulation is new laws, new regulations at the state level, which if you're a multi-state employer, just creates a really complex and difficult matrix to try to manage. So our next poll question has to do just seeing out there how many states you folks have employees in. So in terms of your workforce, both in-person and remote employees, how many states do you have employees working in? 1, 2, or 3 or more?
Still have a few responses coming in. I'll give you guys a few more seconds. All right, 3, 2, 1.
All right, so almost half of the folks on the webinar today have employees in more than 3 states. So speaking to this point, again, it just makes things really complex. You no longer can rely on some of these federal rules and regulations as you once did. You're now, if things are going away, you have to see, hey, what states are these employees in? What are the applicable laws and regulations that apply in those states? And sometimes it'll be, you have a decision to make and there's some strategy involved. Do we go with kind of the most employee friendly state and the rules on that there and have that be our policy? Or do we have addendums in our handbook and treat each employee based on the state that they're in? So sometimes when it's a paid family medical leave or something like that, that's administered by a state, then that decision is kind of made for you. But if it's something else where you have some more discretion, you potentially have some decisions to make. So you want to make sure you do those preferably in compliance with your HR department or short of one of those with someone who kind of has some HR knowledge. All right, so let's cover a handful of court cases. So as I said, there have been a lot of cases where a judge is blocking an executive order or overturning that, things like that. We won't get into too much of that. I want to really focus on the Supreme Court. They were busy. Their their session just ended. So I wanted to talk about a few cases that really could shape best practice for employers going forward. The first of which was a case called Ames versus Ohio Department of Youth Services. And so what happened in this case was there was a white, straight female employee who was working for the Ohio Department of Youth Services, had worked there, I think, for a couple of decades, and had had their supervisor changed to a gay person. They applied for a promotion. They were denied the promotion in favor of someone who was also gay. And then they were demoted in their position and replaced by someone who was also LGBTQ. So this Ames person then sued for discrimination, and some of the courts had thrown that out because previous to this, for discrimination cases under Title VII, which this would fall under of the Civil Rights Act, there was this standard where if you were from a majority kind of not protected class, so to speak, you had to prove that there was some historical discrimination happening by the minority group against the majority group before they would hear your case. So what the Supreme Court decided here was that there is nothing within Title VII of the Civil Rights Act that requires that higher standard that, quote unquote, reverse discrimination cases should be allowed to proceed based on the face of the facts and not have any different standard than any other discrimination case. So what we might see here is, depending on who you speak to in terms of legal experts and HR experts, is you may see an increase of, again, quote unquote, reverse discrimination claims and things like that coming into the courts and coming into litigation. So it remains to be seen. This ruling was just a month or so ago, but it was a significant one at the Supreme Court level. The next was earlier this year. This one was EMD Sales versus Carrera. So what this was potentially going to do was create a higher standard for employers to qualify employees as exempt, meaning that they're paid on a salary basis, not subject to overtime, not subject to the other provisions of the Fair Labor Standards Act. So what the court ultimately decided was no, the current rules and the current test, if it didn't ease the rules any, so you still have that same burden of proof to be able to have employees as exempt workers. But what this case was calling for was the potential for there to be an even stricter standard and kind of kicking back more employees to non-exempt and overtime eligible status. The court did not rule that way, so business as usual in terms of exempt versus non-exempt. The third was Trump versus CASA. And what this did was, as we've all seen, as we talked about in previous legislative updates, sometimes when an agency issues a rule or a president issues an executive order, you'll see a lawsuit pop up and a federal court issues an injunction that kind of freezes that law across the board, across the country. We saw it, the one that comes to mind for me is changes to the Fair Labor Standards Act and changes to who's eligible as exempt or non-exempt. What this case did, this case had to do with Trump's executive order on birthright citizenship. So the Supreme Court didn't side on whether the birthright citizenship was valid or not. What it did do, though, was limit the power of these injunctions from being universal. So what they said was when an injunction is issued generally by a federal court, that it only applies to the plaintiffs. So, if it's a state that's filing suit, it applies to that state. It doesn't apply to the other states. If it's a individual or a company who's getting this injunction, then it only applies to those folks. One potential caveat is class actions. So if there's a large class action that could create a universal injunction, this one is still going to be tested some more. So I don't feel too confident in its application just yet, but it's something to be watchful for as agencies issue rules, as future Trump executive orders are challenged in court. If there are injunctions, how sweeping those are going to be. So this is going to be really important and could, again, create a more difficult compliance matrix if a court issues an injunction and it only applies to certain states and things like that. Going quickly here, Stanley versus City of Sanford, Florida. and Catholic Charities Bureau, Inc. of Wisconsin Labor and Industry. So the Catholic Charities one had to do with a religious exemption. So Wisconsin exempted religious organizations from unemployment insurance. And Catholic Charities Bureau applied for this as a religious institution, but because they weren't directly providing religious services, they were denied. The Supreme Court said that they met the threshold and should be eligible for this exemption. So if you are a religious organization or work with one and have been denied, being able to take advantage and you're not specifically a church and been not denied a religious exemption, you may want to look into that based on the precedent set by this case. And then Massachusetts specific, but I felt it was worth mentioning because I feel like this may come up in other states as well. We had Melee versus Foundation Medicine. So this had to do with non-solicit agreements. So Massachusetts is one of a growing number of states that bans non-compete agreements. And this case had to do with not a non-compete agreement, but a non-solicitation agreement, and whether that counted within that ban. So what the state Supreme Court ruled in this case was that it did not. So this basically empowered, at least in Massachusetts, but I imagine this will apply in other states as well, is that using things like non-solicitation agreements in place of a non-compete is an allowable practice by employers. So if you're not already, if you had been using non-competes before and got away with it because they were made illegal in the states that you're operating in, just make sure that it's legally sound. Definitely review it with HR, review it with legal counsel, but you may be able to utilize things such as non-solicit agreements instead and still have those protect your business. I forgot to mention Stanley. That case had to do with application of the ADA, or the Americans with Disabilities Act. So Stanley sued the city because he was retired, and previously there had been health insurance provided to workers who retired due to disability. The city changed their policy in terms of how long they offered that health insurance, and Stanley sued because of based on ADA discrimination. The federal Supreme Court found that ADA protections do not apply for non-employees and retired employees. So if there are programs in place that involve accommodations or other ADA protections for folks, those only apply while the worker is an active employee. And once they leave employment, those ADA protections no longer apply, according to the Supreme Court. All right, so let's move on to the states. So states have certainly been busy. Expect more of that in the wake of some of these deregulatory actions at the federal level. Here's a quick roundup. Again, I think there were about 38 different state laws that took effect this past July 1st. So definitely check in with HR, make sure there isn't anything that you missed. This is a roundup of some of the more significant ones. So first, we saw minimum wage increases in Alaska, Oregon, and Washington, D.C. New pay transparency laws took effect in Washington State and Vermont. New Hampshire introduced breastfeeding accommodations for businesses with 6 or more employees. So if you're operating in the Granite State, make sure you're in compliance with that. Over in Indiana, where I see we've got some folks on the webinar today, there is an unpaid but job protected leave for employees to attend school meetings for their children. So you're probably going to want to have a formal policy on that if you don't already. Colorado expanded their privacy protections to include biometrics. So if you are an employer that, say, has a biometric time clock in Colorado, or you're otherwise collecting biometric information from your employees, you're going to want to make sure you're in compliance with that. California has expanded their healthcare minimum wage. So you may remember last year they introduced and passed a minimum wage specific for fast food workers. They did already have this healthcare minimum wage in place. It's just been increased to $24 an hour. Drilling in a little bit deeper in California, Los Angeles just enacted a predictive scheduling law specific for retail workers, but it does apply if for any retail establishment that has 300 or more workers worldwide. So a lot of retail businesses are having to deal with this now. It has to do, again, with predictive scheduling, premium pay and penalties if an employee's schedule changes, things like that. Alaska has just passed paid sick leave, so that is now in effect as of July 1st. As I mentioned before, when we were talking about the no tips on overtime, Alabama had a tax exemption on overtime. It was kind of an experiment that expired as of July 1st. So if you do have workers in Alabama being paid overtime, you're going to want to make sure that the state income tax kicks back in on that. And then finally, in the world of non-competes, we're kind of seeing both ends of the spectrum. So first, Florida has passed and enacted what's known as the Choice Act. So this is actually creates the most non-compete act friendly state in the country. So for highly compensated employees, and there are certain definitions of that, it has to do with a certain percentage of the mean wage county by county in Florida. But what it essentially does is allow for highly compensated employers to have one or two options, either a non-compete agreement or a garden leave agreement. So if you are in Florida, if you're thinking about non-compete agreements, make sure you speak with someone who's familiar with that and can help guide you on the best strategy to take advantage and leverage the Choice Act. On the other side of the coin, we've seen non-compete ban expansion in Virginia and an introduction of a really sweeping non-compete ban in Wyoming. So we're seeing those things trend in different directions, but trending nonetheless. So speaking of trends, some things we're seeing, definitely the pay transparency growing quickly. For those of you in Massachusetts, you've got an October deadline there. If you're not already working on it, you're probably behind the 8 ball. You're going to want to make sure that you're on top of that. If you're in New Jersey, that started earlier this year. If you're in Vermont or Washington State, it's starting now. So do make sure that each state's rules are a little bit different. So you're going to want to make sure you're speaking with an expert if you're looking to get in compliance with that. We're also seeing a lot of laws being passed at the state level that are industry specific. So we talked about the California healthcare workers minimum wage. We're seeing some states pass non-compete bans, but just for the healthcare industry. So a lot of these industry specific regulations are for the healthcare realm, but we're seeing some in other industries as well. We talked about fast food workers, retail workers, things like that. So that again just makes things more and more complex for employers, makes practicing HR by Google or ChatGPT even more difficult, if not impossible. So just something to be aware of there. We're also seeing regulations and state laws vary by county. So we talked about the Choice Act and the definition of highly compensated employee varying county to county. One of the more difficult ones to manage is in Pennsylvania. So this one hasn't passed just yet. It passed the House. It's currently in the Senate. But historically, Pennsylvania has observed the federal minimum wage, but there is currently a bill, again, currently with the Senate, already passed by the House, that would create a new minimum wage that's state specific for Pennsylvania. The problem, or not the problem, but the complexity of it is that how the minimum wage works is going to vary county by county. So Philadelphia would immediately go to $15 an hour. Some other counties would start at $10 an hour and increase year over year, but there is basically a matrix of 3 different minimum wage programs depending where you are. So it's one thing to try to manage if you have an office or an employee in Pennsylvania, but you may have offices in a couple different counties, or you may have folks who say, if you have got traveling nurses or home healthcare workers, that might be within the course of a workday traveling between different counties. So this could get really tricky to be in compliance with and something to keep a very close eye on. That, and in addition to the county variation, we're also seeing a lot of these things, this bill included, that would be indexed. So this one, I think, based on the consumer price index, would start being increased based on that in 2029. As mentioned, when we talked about the One Big Beautiful Bill, that restriction on state artificial intelligence laws was not included. So as a result, definitely expect to see more states enacting AI laws. Those could come in all various shapes and sizes, but we'll keep you abreast of the latest there. Child labor laws are going both ways. We're seeing some states create more restrictive child labor laws. We're seeing other states get looser with the child labor law, so that's something to be mindful of. And then, especially with the the Federal Department of Labor saying they're going to be a little bit more lenient with gig workers and independent contractors. We're seeing new programs and protections for those folks passed at the state level. So finally, just a quick HR employer checklist. So some things to do now to make sure you're in as good shape as you can be. First, definitely audit your I-9s, all your kind of new hiring and immigration documents. Again, if you do them electronically, make sure the system you're using is compliant. We're seeing just so many audits on that. So do that. Do it ahead of time yourself before you're having someone else do it at a state or federal agency. Also recommend doing a proactive wage and hour review, both for the Federal Fair Labor Standards Act as well as relevant state laws. We're seeing more audits on those as well. Check your non-compete agreements, your severance agreements. There might be things that you had to take out previously that you can put back in. There might be bans and other regulations that you have to be mindful of. Definitely watch the courts. They're keeping us on our toes. And don't panic based on announcements. Again, things oftentimes have to go through several hoops before they take effect. So when you hear something on the news or you see something announced, don't worry. Just speak with someone who knows what they're talking about, and we'll walk you through it. One thing that a lot of people missed, if you are subject to the ACA, definitely take advantage of the paperwork reduction relief that's now available. So you may have missed it, but starting now, you're still going to have to produce 1095s and file them with the IRS. But in terms of providing paper copies to your employees, that requirement has gone away. You do have to issue a notice that gives them options for how to obtain one if they want it, but you're no longer just going to have to print and mail out 1095 forms to all of your employees. For those of you who are MP clients, we will be sending something out about that soon. So keep your eyes peeled for that. Make sure if you are subject to pay transparency laws now or in the near future, make sure you're compliant with that. But I also recommend, even if you're not, if you maybe fall below the employee count requirements or you're in a state that doesn't have it, pay transparency is really becoming a competitive advantage and sometimes a requirement to be competitive in your recruiting process. We've covered this in previous sessions, but more and more employees or prospective employees, as they're looking at potential employers, won't pursue a position if they don't know what the pay range is for that role. So even if you're not required to, I do recommend at least exploring some at least participation within pay transparency. And then finally, if you're evaluating a return to office protocol, if you've got remote workers now that you want to get back on site, plan that carefully. It's not something you want to rush. Think about your communication strategy. Think about objections. Think about accommodation requests. There's a lot that goes into that that you want to strategize on. If you're considering a reduction in force, I know a lot of companies out there are facing a tough economic outlook. They're facing some tough times. Before you lay people off, I highly recommend at least looking at work share programs. So more and more states have these available. It's a way to reduce the hours that some of your employees are working, allow them to collect some of their lost wages through unemployment, but still keep them on payroll. Can be a really great option for certain employers. So if you are thinking about laying folks off, definitely look into work share first. Also, we're seeing more companies entertain mergers and acquisitions. If you're thinking about selling, I highly recommend doing some proactive due diligence, getting ahead of that, because that can be a real headache and can jeopardize a deal that you feel like you got it in the bag. If you're growing, if you're in a more fortunate position and adding employees, definitely watch those employee counts, more and more regulations that will apply to you as you grow. And also watch where you're adding those employees. If it's new states, make sure you're prepared for those. And then just some general best practices if you're looking to minimize and control who you have on board and reduce turnover. Think about doing some employee engagement surveys. Think about doing some stay interviews, getting a good pulse for employee satisfaction and employee engagement. I think those are always great. That's something that we can do through HR services here if you subscribe to that. And then finally, invest in your managers and supervisors. Make sure they're up to date on all the stuff we just talked about. They serve a really critical role and layer within your organization, and they act as agents of your company. So if they're not in compliance with all these laws we just talked about, then you as a company are not in compliance. So they can really be a huge exposure and liability for your organization. Whereas if you train them properly on both the soft skills and the hard skills and the HR and the compliance, they can really be a huge asset to your organization. So take the time and spend the money to invest in that layer of your business. All right, so it looks like we have a couple questions, and I'll get to these as appropriate. So, A, what if we use E-Verify through our payroll provider? So using E-Verify is a great step. Still want to make sure that you're keeping proper records of everything, that just like anything with a payroll provider or a payroll service, you're still liable for any violations. So do make sure you're keeping records of everything, even if you do use E-Verify. Regarding TPS, so if a current employee is working under a TPS and the TPS is still valid, can they continue to work, or is their work authorization automatically canceled? Great question there. So it really depends. I know like Venezuela, for instance, has a couple different ones. So you're going to want to either consult HR consulting or legal counsel. When a TPS is terminated, there's usually a time period before that work authorization is revoked. So, and a lot of times it'll be specific on what the date is on that employee authorization document. So those generally aren't specific to the employee. It's specific to the TPS that they qualify for, that it'll say this employment authorization document is valid until October 30th, 2026. Sometimes it'll be a past date, but the Department of Homeland Security will issue a continuance of that. So what you'll want to do is inspect that termination notification of the TPS, and it'll say this revocation or this termination of the TPS applies to employment authorization documents that are dated October 30th, 2026, for instance. So you're going to want to look at what the termination is and which EADs it applies to. If cash tips includes tips given via credit card, does this mean we no longer are able to deduct taxes through payroll? No. So they did actually kind of expand the tax relief for employers on the no tax through tips provision. So we'll have more on that to come in future communications and future presentations, but it still is advantage for employers as well. And the last, it looks like someone's asking for a copy of the slides. We will, following today's presentation, send out a PDF of the slides. So everyone who registered will get a copy of that. So I apologize, I went a few minutes over. Thank you for your time. I did my best to get as much in as brief time as possible. Sorry if I spoke fast, but I'll hand things back over to Lauren. Thank you, everybody.
All right, thank you all for joining us. We know how much HR pros and business leaders have on their plates, and we hope today gave you some clarity and maybe even a head start on the compliance changes coming your way. We hope you're leaving with some fresh ideas and maybe even a few aha moments on how to boost engagement, build stronger teams, and lead more intentionally. A few important follow-ups before we let you go. The webinar recording and slide deck will be sent to your inbox shortly. We'll also be sending you instructions for claiming your SHRM credits. And don't worry, we'll be creating more content and resources around all the topics covered today so you can stay informed and prepared as things evolve. If you're feeling like keeping up with legislation is a full-time job in itself, well, that's exactly why MP exists. Our HR service isn't just reactive support, it's proactive partnership. If today raised questions specific to your organization, don't hesitate to reach out. We're here to help. Join us in 2 weeks for our webinar, Immigration and I-9 Compliance in 2025, What You Can't Afford to Miss. If you are interested in attending that one, we will send you a link in the follow-up email, and it's in the chat right now. You'll also see a link for a short survey pop up in the chat. It takes less than a minute, and it's the best way to let us know what you need, or if you'd like to schedule a quick strategy call with Paul or someone from our team. Thanks again for spending part of your day with us, and we'll see you at the next session. Have a great day.